As the Court pleases, Justices of the Constitutional Court, I appear on behalf of the applicant in this matter.
I appear for the second respondent in the matter.
As it pleases this Honourable Court, Justice of the Constitutional Court, I appear on behalf of the first respondent in this matter.
Pleases the Justices of the Constitutional Court, I appear on behalf of the sixth respondent in this matter.
As pleases the Court, Justices of the Constitutional Court, I appear on behalf of the intervening party.
The events that have led to today's judgment are well known. This is a unanimous judgment written by me in which Mogoeng CJ, Zondo DCJ, Beson AJ, Cameron J, Dlodlo AJ, Goliath AJ, Kampepe J, Mhlanhla J, Petse AJ, and Tron J concur. In Black Sash 1, costs were reserved, and the then Minister of Social Development, Minister Dlamini, was called upon to show cause on affidavit why she should not be joined to the proceedings in her personal capacity and why she should not pay the costs of the application out of her own pocket. In response, affidavits were filed that raised conflicts of fact in relation to an alleged parallel process of responsibility initiated by Minister Dlamini. Following upon this, in Black Sash 2, we ordered that Minister Dlamini be joined in her personal capacity and that the parties report to the court whether they agree to a process in terms of Section 38 of the Superior Courts Act to determine the issues relating to her role and responsibility in establishing the parallel decision-making and communication processes. The parties agreed on a referee, and retired Judge President Ngwepi was appointed to conduct the fact-finding inquiry. The inquiry took place and the inquiry report was delivered to this court. It found that Minister Dlamini misled the court to protect herself from the consequences of her behavior. She allowed a parallel process to occur knowing that she withheld information that might lead to her being held personally responsible for the social grants disaster. The inquiry report was made public and the parties were called upon to file submissions on whether, in the light of the findings of the inquiry, Minister Dlamini should be held liable for the costs out of her own pocket. Minister Dlamini's primary submission was that it would be an impermissible encroachment into the domain of Parliament should a personal costs order be made against her. This argument has no merit. When courts make cost orders, they do not make judgments on the political accountability of public officials. They do so only in relation to how the rights of people are affected by the conduct of a public official who is not open, transparent, and accountable, and how that impacts on the responsibility to a court by those involved in the litigation. And as explained in Black Sash 2, the common law rule for holding public officials personally responsible for costs are now buttressed by the Constitution, and I quote, "Within the constitutional context, the tests of bad faith and gross negligence in connection with the litigation applied on a case-by-case basis remain well-founded. These tests are also applicable when a public official's conduct of his or her duties or the conduct of litigation may give rise to a costs order," unquote. In relation to the reason why Minister Dlamini did not disclose to this court that the individuals were appointed at her in the parallel inquiry and that they had to report directly to her, the inquiry report was diplomatic but nevertheless damning. In essence, it found that Minister Dlamini had failed to make full disclosure to this court. The inquiries report that the Minister's failure to disclose this information was her fear of being joined in her personal capacity and being mulcted personally in cost has not been and cannot be faulted. The inference that she did not act in good faith in doing so is irresistible. At best for her, her conduct was reckless and grossly negligent. All that is sufficient reason for a personal costs order. This conclusion is a serious and sad one, especially in the context of provision of social grants to the most needy in our society. But if it is not to happen again, consequences must follow. It has been a sorry saga, and it is proper that Minister Dlamini must, in her personal capacity, bear a portion of the costs. It would account for her degree of culpability in misleading this court, conduct which is deserving of censure by this court as a mark of displeasure. More so since she held a position of responsibility as a member of the executive. Her conduct is inimical to the values underpinning the Constitution that she undertook to uphold when she took up office. The report by Ngwepi JP revealed that she misled the court to protect herself from the consequences of her behavior. She allowed a parallel process to occur, knowing that she withheld information that would lead to her being held personally liable for the social grants disaster. The office which she occupied demands a greater commitment to ethical behavior and requires a high commitment to public service. The Department of Social Development is as much responsible for the realization of rights outlined in the Constitution as this court is, and she used her position as minister to place herself between constitutionally enshrined rights and those entitled to them. It is a difficult issue to determine the proper extent of the personal costs order. The determination is a discretionary one for the court to make. We have to consider Minister Dlamini's personal responsibility arising from the parallel process she set in motion and her shielding this truth from the court against the fact that ordinarily state officials do not bear personal responsibility for the good faith performance of their official functions. It is a novel matter to hold a cabinet minister personally responsible for the costs of litigation. In the circumstances, it will be appropriate to order that she must pay 20% of the taxed costs. These costs exclude the costs of the inquiry. A last and unedifying matter remains. The inquiry's report's findings suggest very strongly that some of Minister Dlamini's evidence under oath in the affidavits before this court and orally before the inquiry was false. The register of the inquiry judgment to the National Director of Public Prosecutions to consider whether Minister Dlamini lied under oath, and if so, whether she should be prosecuted for perjury. In the circumstances, the following order is made. 1. The first, second, and third respondents are to pay 80% of the costs of Black Trust and Freedom under law in the application, including the costs of two counsel. 2. Ms. Bathabile Dlamini, in her personal capacity, is ordered to pay 20% of the costs of Black Trust and Freedom under law in the application, including the costs of two counsel. 3. The registrar of this court is directed to forward a copy of the inquiry report and this judgment to the National Director of Public Prosecutions to consider whether Minister